everyone. I am Dr. Dina Zuvala. Welcome to another installment of our seminar series, The Politics of International Law. Before I get started, I want to, of course, acknowledge that I'm here in Canberra on the lands of the Nawago and Ngambri people, and I would like to acknowledge their that sovereignty was never ceded over these lands, and to pay my respects to elders past, present, and emerging. This is, as I already said, another of our Politics of International Law seminars that takes place under the umbrella of the ANU College of Law and the Center of International and Public Law. And the whole idea of this seminar series is to bring in conversation scholars across disciplines, across departments, to discuss their work in an interdisciplinary or interfaculty manner. And for this reason, I'm really delighted to be welcoming today as our external speaker, Dr. Julia Dehm. Dr. Dehm is a senior lecturer at the Trobe Law School. Her work addresses issues of international and domestic climate change and environmental law, so things that are very also central to the Australian election debate, national resource governance, and questions of human rights, economic inequality, and social justice. And today, Julia will be discussing basically her first monograph, Reconsidering REDD, Authority, Power and Law in the Green Economy. Her monograph was published in 2021 by Cambridge University Press. And of course, it was recently awarded the 2021 ECR Publication Prize from the Law and Society Association of Australia and New Zealand. She will be discussing her work in conversation with Professor Sango Mahanty. Professor Mahanty is our colleague here at the ANU Crawford School of Public Policy. And her work, she's a human geographer whose work focuses on the politics of social and environmental change. She recently held an ARC Future Fellowship that explored the themes of social and environmental change in the region of Cambodia, Vietnam, and this resulted in her recently published monograph, Unsettled Frontiers, Market Formation in the Cambodia, Vietnam borderlands, that was very recently, I think this year, published by Cornell University Press, and I encourage you all to have a look. And she currently works on questions of how communities and civil society are responding to dramatic processes of nature's society transformation. And in her work, she also works closely with governments and the civil sector, the civil society sector. I will stop now. I will thank both our presenter and our commentator for being here. And I think I will give the floor to Sango to kick off by asking Julia a few questions before Julia starts with her presentation.
Oh, Dina, I'd be really happy to come in after Julia.
Okay, perfect.
Okay?
It is perfect. I misunderstood. I'm sorry. Okay, in that case, Julia, you have anywhere between 25 to 30 minutes, and we will continue with questions. And I also want to say to the audience, if you have any questions, feel free to start dropping them in the chat so that we have a sense of how many questions we have for Julia. Julia, the floor is yours.
Thank you so much. And thank you, Dina, so much for this invitation to speak today. And I'm very grateful to Sango for agreeing to act as commentator. I'm really looking forward to the discussion. Before starting, I also want to acknowledge that I'm speaking for the lands of the Wurundjeri peoples of the Kulin Nation and that their sovereignty has never been ceded. And this acknowledgement is always important, but I think it's especially important when thinking about how we might live well together in the Anthropocene, that we acknowledge the multiple laws that are in this place and that long history of Indigenous care for country. It gives me great delight to be speaking to you today about my book, Reconsidering REDD, Authority, Power and Law in the Green Economy. It was published last year, and because of all the lockdowns and the pandemic and everything, there hasn't been that many opportunities to presented. So I'm really delighted to have this chance to sort of share some of the key themes and ideas with you. The central question that the book grapples with is how we as an international community are responding to the climate crisis. The recent Intergovernmental Panel on Climate Change report confirmed what we've known for over a decade, that it's unequivocal that human activities have fundamentally transformed our climate, that a certain level of warming is now locked in, something that we're already seeing the devastating effects of, and that the decisions that we make in the next decade will crucially determine future trajectories and the lives and livelihoods of millions. The Glasgow Climate Summit, COP26, in December last year was therefore widely seen as a crucial moment for galvanising climate action and increasing ambition. The key outcome document, the Glasgow Climate Pact, was significant because it was the first time after 30 years of climate negotiations that a COP decision talked about the need to phase down fossil fuels and to address ongoing state support for fossil fuel extraction through subsidies. Yet there were still no actual concrete plans to do so. And although a study published this month has confirmed that if all conditional and unconditional pledges under the Paris Agreement are implemented in full and on time, warming could just be kept to below 2 degrees. Glasgow really failed both in supporting action that's commensurate with the scale of the crisis and promoting the types of urgent society-wide transformations that are necessary to limit warming to 1.5 degrees Celsius. Where it also has failed is in answering the demands of climate justice, especially for climate finance, to support mitigation, to support adaptation, and to provide compensation for the effects of climate change that communities around the world are already suffering, or what's called loss and damage in UNFCCC speak. But what Glasgow really did do is put in place the regulatory infrastructure to enable the expansion of global carbon markets, now predicted to be worth $100 billion a year, that could potentially enable the delay of much needed action to phase out fossil fuels, while further intensifying the greater commodification and financialisation of nature. What dominated the discussion is this language of net zero, the assumption that it's possible to achieve a balance between anthropogenic emissions by sources and removals by sinks or greenhouse gas emissions. Over 730 civil society and Indigenous peoples groups signed a statement calling for real solutions, not net zero, and described net zero as a cover for business as usual and as a way of avoiding responsibility for past, present, and future emissions. And I'll just quickly quote, they say, net zero emission targets disguise climate inaction and distract from the necessary and urgent work of phasing out fossil fuels at source and localising sustainable food systems and economies. Polluters' net zero schemes are based on multiple myths and a little more than public relations campaigns. They blithely rely on assumptions that carbon offset, tree plantations, bioenergy, and dangerous distractions such as hydrogen and carbon capture and storage will somehow keep or take emissions out of the air after polluters have done their damage. Unproven technologies have repeatedly failed and have yet to be realised and remain non-viable at scale, are being imagined as supposed solutions for continued emissions. From carbon capture and storage to direct air capture to burning plastic waste for fuels, these technologies extend and deepen the fossil fuel economy that drives the climate while imposing profound new risks on frontline communities around the world. My book provides a detailed look at a specific climate change response, namely the reducing emissions from deforestation and forest degradation, or REDD scheme, that's key to sort of scaling up global carbon sequestration. So REDD is a scheme to address the contribution of greenhouse gases from deforestation and forest degradation. And what's been particularly controversial is the still not yet confirmed after over a decade of negotiations, proposal that REDD could operate as a carbon offset scheme where countries in the global north provide financial resources to promote the reduction of deforestation and forest degradation in the global south, and in turn can count the saved carbon dioxide emissions towards their own international mitigation commitments. The animating concern of this book is that the dominant international legal responses to climate change, particularly this marketized vision of a green economy, replicate and indeed further intensify already existing legal relations of domination, exploitation, and marginalisation. Grassroots Indigenous and climate justice activists have critiqued REDD as a lag-grabbing false solution to climate change that has privatised the air we breathe, that uses forest, agricultures and water systems in the global south as sponges for industrialised countries' pollution, and seeks to bring trees, soil and nature into a commodity trading system. They've condemned REDD as a mechanism that, and I quote, steals your future, lets polluters off the hook, and is a new form of colonialism. The Indigenous Environment Network has described REDD as CO2 colonialism. And this term, carbon colonialism, draws attention to the dangers that strategies to mitigate and address climate change reproduce and further perpetuate unequal global relations and facilitate further control, authority and power over land and resources in the global south. Initially, the term referred to the unequal appropriation of carbon or atmospheric space and the history of deeply unequal emissions of greenhouse gas emissions, which allowed countries in the global north to become wealthy by pursuing a carbon-intensive model of development, which countries in the global south were now prevented from pursuing. Subsequently, the term came also to be used to describe the effects of marketised climate mitigation approaches, such as emission trading schemes, and the ways they enabled the articulation of new forms of power, authority, and control over land and resources in the global south. Taking inspiration from these criticisms, my book provides a critical reading of the logics and effects of the REDD scheme. The book argues that REDD needs to be analysed not just as a problematic false solution to climate change, but also as an ambitious project that is reorganising how forested land in the global south becomes an object for international and transnational regulation. It engages with and builds upon numerous critiques of REDD that have highlighted its clear limitations as a climate mitigation strategy, but the primary contribution of the book is to examine the productive effects of this type of international climate policy and to interrogate the sort of world that REDD assumes and looks forward to. It understands REDD as both a vision of market-oriented environmental governance and a series of practices and processes directed towards actualising and implementing this ideal. The book maps how REDD reconfigures global authority over forested land and forest resources in the global south, paying attention to the processes of agreement making under the UNFCCC and the development of legal and governance frameworks for REDD at the national level, but also to transnational practices of agreement making, of contracts, and of capacity building through development institutions. A key focus of the book is on the social dimensions of REDD, given acute concerns that REDD risks dispossessing or impacting the livelihoods of the 1.6 billion people who live in and around forested areas globally, 200 of whom identify as Indigenous, 200 million, of whom identify as Indigenous. Forest communities, so part of the unique contribution of the book is showing how even the main strategies promoted to protect forest people from the potential adverse impacts of REDD, namely tenure reform, benefit sharing mechanisms, and free, prior, informed consent, shouldn't be primarily understood as ameliorative, but that these strategies actually further consolidate these new forms of global authority by working to transform forest peoples into ecosystem service providers in the new green economy. There's rightly been considerable concern about carbon cowboys and case studies where unscrupulous actors have, often outside the law, imposed fraudulent contracts on communities or sought to evict them from their lands in the names of these sort of conservation projects. And this follows a long history of conservation projects being implicated in the creation of conservation refugees. And so while a number of legal scholars have sought to ensure that certain safeguards are put in place to protect the rights of forest communities and Indigenous peoples, I was concerned to understand how these critiques and the proposed responses created their own instrument effects and contribute towards a certain institutional proliferation and practice. So while the promotion of social safeguards has mitigated the potential abuses in REDD implementation and provided important tools that can be deployed by communities to protect their interests within REDD projects, I suggest that these mechanisms offer only limited possibilities for resisting REDD or resisting the articulation of new forms of global authority that is produced through these schemes. Understanding these mechanisms is not simply potentially inadequate ameliorative measures, but as productive and new governance relations, allows for an examination of how they may in fact operate to help create the forms of legibility, the subjectivities, and the social relations that may further consolidate the reorganisation of authority that REDD represents. So on one level, this book is focused on quite a niche area at the intersection of forest governance, climate change law, and Indigenous people's rights. And I hope that the book is of interest to people in these fields. However, I really try and situate REDD within the frame of this green economy that's being co-produced alongside it, and which is facilitating the greater economisation, marketisation, and financialisation of nature, and show that contestations over REDD are not just significant in their own right, but are also significant because they're emblematic of broader struggles over different modalities of environmental governance and how the relationship between the economy, society, and the natural world should be configured. I also hope that methodologically the book offers some important resources for people working on critical approaches to global governance, especially from perspectives orientated towards concerns of the people of the Global South. And I think the book does intervene in a number of international legal debates. Firstly, it provides a critical account of the work of international climate law and some of the implications of the turn towards market-oriented forms of governance. In addition, it highlights the limitations of viewing international environment law as concerned with developing tools to bridge the North-South divides, and shows how at times international environmental law itself is implicated in the reproduction of difference between the global North and the global South, and the continuity of neocolonial relations. It also reveals the way in which international and transnational law is complicit in forms of appropriation of land and resources, thereby contributing towards the literature on land grabbing. Further, the analysis speaks to the shifting ways in which global authority is articulated and actualized in the contemporary capitalist economy through the concurrent operations and mutual co-constitution of public and private laws. It thus highlights the need for the standard public-private divide to be disrupted in the analysis of contemporary as well as historical relations of global domination and imperialism. And finally, given that REDD implementation poses distinctive challenges for coordination between the global, the national and local scale, this book interrogates how the operations of global governance distributes rights, powers and obligations between scales, and illuminates processes by which authority is globalized while responsibility is localized. So our present moment, I think, really raises uncomfortable questions about responsibility, culpability, and what it means to live well in the Anthropocene. It's clear that the core assumptions of many disciplines, including the doctrines, principles, and processes of international law, need to be rethought in a context where the once presumed environmental stability no longer exists. The ecological crisis has led to a revitalisation of scholarship, critically interrogating how international law has contributed to the production of Anthropocene conditions by perpetuating an extractivist relationship to nature, and the need to remake international law's relationship with the natural world. There's a growing chorus of scholarly voices calling for a different conception of law, which acknowledges and in fact emerges from the tangled nature of existence. Yet, unfortunately, this book's not focused on this sort of rapture and, the ways in which law can contribute towards living well in the Anthropocene, but rather is really tied up in these questions of how the prosaic day-to-day developments in the field of international legal practice are arguably marked more by continuities rather than dramatic breaks from the norm. And it's these questions of how existing structural power relations and sedimented historical conditions continue to influence our response to the climate crisis. But I think these two projects of imagining how law can contribute towards living better in the Anthropocene, and this critique of the way in which the continuities of law continue to produce these marginalizations and inequalities necessarily need to go hand in hand. Namely, that in order to respond to the legal implications of the transformation that the Anthropocene is demanding of us, I think we need to contest the ways in which existing power relations continue to influence responses to the climate crisis, to disrupt these continuities in international legal practice, and to create openings for the ruptures or enact the in order to enact the transformations that this moment demands. So in my remaining time, I quickly want to provide an overview of some of the various chapters in the book to give you a sense of what it covers. So the introduction, as well as sort of introducing the themes of the book and presenting its core arguments, it introduces a configuration of 4 concepts, organizes 2 pairs of 2 through which to understand REDD. The first pair of concepts, namely climate justice and the green economy, provides a means of situating and conceptualizing REDD. The concept of climate justice and its multiple dimensions, procedural, distributive, historical, and what I call structural justice, namely critically interrogating the processes through which injustices have been produced, including the logic of pro-growth capitalism and neocolonialism. With the concept of the green economy, I seek to point to the wider transformations that REDD is inherently intertwined with, and the way in which this discourse of a green economy is facilitating the re-legitimation of green growth and the greater economization, marketization, and financialization of nature. This concept of the green economy has become a new discursive frame for environmental politics, which gained traction in the lead up to the 2012 UN Conference on Sustainable Development, even though it only received cautious endorsement in the outcome documents due to civil society opposition. But the green growth or green economy frame, I argue, seeks to sustain the legitimacy of continued economic growth and thereby facilitates the further expansion of economic logics and markets into previously uncommodified domains of life. In particular, the frame of the green economy has helped to reconceptualize the natural commons as natural capital, and has as a broader effects to value nature and ecosystem services in economic terms, on the premise that the abstraction and pricing of nature and its transformation into assets, goods and services will mean that environmental risk and degradation can be measured, exchanged, offset and generally minimised. In doing so, this idea promotes a highly reductive way of making nature visible and legible in substitutable and fungible terms, one that ignores complex social and ecological entanglements and dismisses other logics of evaluation. The second pair of concepts, power and authority, speaks to the amalgamation and consolidation of global authority over forested areas, but also simultaneously the plural and diffuse means by which authority is exercised in REDD, through the devolution, decentralisation, and pluralisation of increasingly polycentric forms of governance. The book deploys a Foucauldian understanding of power as a way of acting on an acting subject, consisting of guiding the possibility of conduct and putting in order a possible outcome. For Foucault, therefore, to govern is to structure the possible fields of action of others, a process of conducting the conduct of individuals so as to optimise relations in a specific milieu. I provide a critical account of this concept of polycentric governance that's getting increasing dominance in climate law literature, and trace how it came to be taken up in climate law through an influential paper written by Eleanor Osram, and then examine how the concept was deployed by the Indiana workshop on political theory that she directed with her husband, Vincent Osram, and how he in turn took the term from Michael Polanyi, who was using the term to think about the process of spontaneous ordering in market economies. And I think this sort of genealogy helps us think a little bit more about the politics of this form of governance. And finally, my overarching analytical concept is authority, which I think helpfully draws our attention about how new forms of global authority come to be instituted through representational practices and other technical means. And throughout, I highlight how, although authorities tended to be associated with public law and questions of sovereignty, in the context of a globalised world, increasingly attention needs to be paid to how private mechanisms of governance and private market arrangements gain de facto standing as forms of public authority. So the first chapter then provides a background of the history of REDD on a number of different registers. I examine it as a legal agreement under the UNFCCC that's made it possible to treat actions or activities to protect forests, to make them legible in terms of a unit of 1 tonne of CO2 equivalent. I look at REDD as a concept or an idea that forest protection can be incentivised through the increased economic valuation of natural capital or ecosystem services that emerge from the field of environmental economics. I also look at REDD as a series of practices, experimental and preparatory design to actualise REDD, including through demonstration activities and what have been called REDD readiness initiatives, including by the Forest Carbon Partnership Facility of the World Bank. And then finally, I look at REDD also as a project of social transformation in the lives and livelihoods of people living in and around forested areas. I show how initial concerns that REDD could present a risk to the livelihoods of people living in and around forested areas was quickly responded to with an alternative discourse that REDD could present ways to achieve co-benefits for forested people. And then there was a convergence around the idea of people talking about risks and people talking about benefits, that safeguards had to be included in order to reduce risks and promote these benefits. Safeguards such as tenure reform, benefit sharing, and rights to consultation and free prior informed consent. What's lost in the shift, I argue, is a discussion about whether REDD should be implemented, and in favour of a discussion of how it will be implemented. The following chapters then, in many ways, I think, just sort of take this strange object or scheme of REDD and turn it around and examine it from slightly different angles with different analytical perspectives. So chapter 2 takes up the idea of authority and is concerned with how a claim to global authority over land and resources in the global south was invoked and the shape and form this authority was given. I show how the designation of both climate change and biodiversity loss as matters of common concern have operated to authorise a form of global jurisdiction over activities and processes that contribute to these very problems within nation states. My concern is that although purportedly global in scope, this authority is in fact, in practice and in fact very differentiated and targeted on activities within the countries of the Global South. I show this by demonstrating how certain ways of thinking about addressing climate change focused on substitutable, exchangeable emission reductions rather than others, such as keeping fossil fuels in the ground, have been adopted, and how imperatives of cost effectiveness and efficiency have structured international legal responses to climate change. And that this has then created a narrative where changes to land use patterns or small scale and subsistence farmers is seen as globally the most efficient way to address climate change, while the actions of those who are most historically responsible for causing the harms of climate change remains much more obscured from international attention. This chapter also examines how, due to forest functions, as a carbon sequestration sink, deforestation has come to be seen also as a matter of global concern, despite a long history of post-colonial states in the South asserting that deforestation was a matter of national rather than international concern. I also highlight how REDD promotes certain approaches to addressing global deforestation, focused on issues within tropical forested countries, rather than addressing the global dynamics that are driving deforestation and demand for the commodities that produce deforestation: palm oil, timber, pulp, animal feed, that have been obscured from view and from policy focus. So the question of how this claim to global authority is actualised and enlivened in practice is taken up in chapter 3. Here I look at the legal forms of property and contract and how they're central to the actualisation of these new forms of global authority through REDD. I look at how transnational contracting is used to secure future-orientated promise to ensure additional carbon sequestration in forested land in the Global South, paying attention to the power dynamics involved in drafting such contracts and the construction of their terms. I highlight the crucial role played by the carbon finance sections of the World Bank in driving this marketised response to climate governance, and how many of its specialised funds have actively sought to preempt decisions made by the UNFCCC and its annual conference of the parties. I also highlight how in developing template contracts for carbon reductions and carbon sequestration that are then adopted throughout the market, the bank has played a crucial role in shaping the regulatory environment in often invisibilised ways. This chapter also examines REDD through the idiom of property, interrogating the carbon commodity as this really strange quasi-property right in emission reductions. This commodity, I argue, is very particular, partly because it's solely a product of law, and that demand for it and its value is therefore also just a product of regulatory schemes. The carbon commodity also, I argue, is caught between these imperatives of standardisation, where carbon from anywhere is treated as fungible with carbon from anywhere else, what's necessary for a liquid, smooth market, but also those demands to ensure environmental integrity and social integrity, and to focus on the specificities of certain offsets or emission reductions and how they have been produced. So this constant tension between the particular and the general. And I also pay attention to how the initial creation of emission reductions and allocation of them in the international, through the international legal frameworks of Kyoto and Paris, has sort of created an unequal distribution of giving most of these rights to emit to countries that are most historically responsible as well. So chapter 4 then provides a critical examination of a key effect of REDD, namely the resignification of how questions of responsibility in the international climate regime are understood. The principle of combat differentiated responsibility is a crucial principle of international climate law that reflects notions of redistributive multilateralism, identifying that developed countries should take the lead on climate change, although there's always been a constructive ambiguity if developed countries should be taking the lead because of the greater responsibility that they bear for their contribution towards climate change, an interpretation that's always been strongly resisted by the US in particular, or because of the greater technical, financial, and regulatory capacity that developing countries have to take climate action. So I trace the history of this concept through the UNFCCC, Kyoto, and then the Paris Agreement, and show how the more potentially redistributive elements of this concept have been neutralised over time in how it's been implemented and actualised. I argue that with the emergence of market-based responses to climate change, there's been a recasting or resignification of this concept in a way that precludes a proper accounting of the differentiated responsibilities that countries have arising from their contribution towards causing climate change, and instead that a focus on the purported lack of capacity of global South countries to take climate action is used as a justification or authorization of greater international intervention in the name of assisting them to act on climate change. In REDD, we see how the language of capacity building is being used by development institutions to expand international intervention in REDD host countries, and in particular, to establish the regulatory infrastructure necessary to enable expanded carbon markets. I highlight that these international interventions, therefore need to be seen not just as neutral assistance, but as actively producing and shaping a specific political economy in states of the global South in the name of the green economy. Chapter 5 then considers questions of scale and interrogates the multi-layered system of governance that REDD envisions. This chapter is focused on the property law dimensions of vertical coordinations across scale, describing and analysing how the disaggregation of property rights also operates as a key legal technology for globalising authority over forested land and transferring authority to international actors and away from local communities. Here, I was interested in how in some of the literature in REDD, there was a strategic recognition of communal forms of ownership of forested lands and or legal pluralism in forested spaces, but how this hybridity ultimately worked to facilitate the disciplinary inclusion of common property regimes into global carbon markets. In this chapter, I try and unpick the politics behind some of the very technical literature on carbon property rights, but also to critically review how the conditional recognition of common property regimes was used as a development strategy since the early 90s, and draw attention to how these models promote conditional self-governance of local communities, but simultaneously work to ensure that local self-governance is only exercised in specific ways that facilitate global interests. And then the final substantive chapter turns to examine REDD implementation on the ground and the governance of REDD at the local level. It's here that I interrogate 3 of the strategies that have been central to debates on safeguards of REDD, namely benefit sharing, tenure reform, and rights to consultation and free prior informed consent. I argue that all of these strategies are caught between these imperatives of rights realisation from below, but also imperatives of greater responsibilisation from above. So trying to also turn people into contractual subjects. It thus suggests that the impacts of such measures might not necessarily be emancipatory for forest people, but rather that such strategies may operate to facilitate the greater disciplinary inclusion of forest people in the so-called green economy. I also provide an account of how international legal frameworks have required Indigenous peoples to often perform specific subject positions or attributes and present themselves in specific ways, often in this context as traditional or as ecological stewards, in order to claim the rights to be afforded by legal protections, and how this has created a context where it becomes very hard for forest communities to present themselves or to be simultaneously read by international actors as both Indigenous and as not consenting to REDD. Thus, the analysis in this chapter suggests that these safeguard mechanisms play a crucial role in establishing new forms of global authority over forested areas by reorganizing social relations and transforming people who, in and around forested areas, into responsibilized project participants and payment for ecosystem service providers in the green economy, thereby facilitating their disciplinary inclusion in global carbon markets in ways that risk displacing the social responsibilities of global elites to reduce their own oversized carbon footprint. So in closing, I want to return to the underlying concerns animating the book, namely the responsibilities and obligations that are entailed in a just cohabitation of a shared planet. I suggest that there are other ways that the problems of climate change and deforestation could be approached, and I draw on statements by people living in and around forested areas who are resisting REDD to demonstrate what some of these possible alternatives look like. And thus, although the unfolding ecological crisis will invariably shape our personal and collective future lives, I try and stress that the contours of possible futures are not yet fixed and remain contested, even as I trace the emergent relations of law, power and authority in one dominant but not inevitable future trajectory, namely the green economy and associated agendas to make nature legible in economic terms and governable through market mechanisms. I very much hope that instead other pathways are taken, that we heed the leadership of frontline communities that are resisting new fossil fuel infrastructures, that we critically unmake the ways law has enabled an extractivist relationship to nature, and reimagine different forms of legal relations between the human and the natural world. But in order for that to happen, I think we also need to be alert to the dangers inherent in some of the potential trajectories. And that's what I hope this book does. Thank you.
Thank you very much, Julia, for this very, very rich talk. And of course, those who want to find out more can always purchase and read your book. I think I will give the floor to Professor Mahanty now, to Sango, to ask a few questions.
Okay, thanks, Dina, and thanks so much for inviting me to be a discussant in Julia's seminar today. So I've been involved in more grounded research on REDD+ schemes, and it was really interesting for me to go through some of Julia's work, including her new book, which looks really great, and I recommend it to all of you. And also, especially to kind of get that broader international legal perspective on REDD+. And I think Julia also contextualized her work really nicely today within recent developments in the Glasgow Conference of Parties and the continued focus on net reductions, which means there will be ongoing attention to these kinds of schemes, even if they change form here or there. And I have to say that Julia's critique of REDD+ resonates very strongly with my own empirical experiences, which are mainly in Cambodia and Vietnam, or mainland Southeast Asia more broadly. I think that Julia's analytical approach with her two paired lenses is quite a useful way to think about REDD+ and to sort of pull apart what's going on here. The climate justice green economy lens helps to expose sort of the differentiated benefits and costs associated with REDD+, and it positions REDD+ within this larger suite of green economy interventions that are all about commodifying nature in some form in order to protect it, but comes with a whole lot of simplifications, I guess, for want of a better word, or to kind of capture a whole lot of different issues and problems, simplifications both of nature and of our relationships, complex multidimensional relationships with nature. And then I think the second analytical pairing of power and authority really helps to expose how REDD+ can function as a mechanism to exercise global and structurally entrenched forms of power and authority over forested lands. As Julia says, you know, turning forests in the global south into an object for international and transnational regulations, and where authority is globalized and responsibility is localized. That was a very nice set of summarizing words, I thought. And I guess the other thing that I tuned into a little bit in Julia's talk just now was kind of local contestations that also make their way into global fora, like the Conference of Parties around REDD+, which shows that these unequal costs, benefits, and power relations are not going unnoticed. In fact, they're very much noticed by those who are most immediately impacted by these sorts of schemes. And I guess one thing that especially fascinates me, and I think Julia's observed this too, is the sort of extreme persistence or stickiness of these kinds of approaches. So we've had something like a decade of experiments with this model, REDD+, and there's been a lot written on this now, including Julia's book now. And, you know, I couldn't tell you, like, literally, I've gone through this literature in a lot of detail myself for my own research. And, you know, you think, man, there are so many issues, so many challenges, problems. But, you know, the concept of REDD+ still has traction. It still has a life, still has continued interest from donors, from governments, from the international community. So we really need to think about kind of what's going on here and why, you know, why does it carry so much favour. And I guess, you know, Julia's proposing that, well, it provides kind of this neat solution whereby we don't need to look more deeply at our fossil fuel extraction and use, among other sorts of changes that might otherwise be required if we weren't focusing on net reductions. So I think having sort of worked closely in a research capacity on REDD projects on the ground, I can only agree with this kind of fairly critical reading I think that Julia's given us. And I think indeed the problems aren't just limited to the UNFCCC driven mechanism of REDD+, but also seem to infect the voluntary carbon market. Yeah. And we've been seeing kind of echoes of this recently with criticisms of Australia's own carbon offset scheme, the National Climate Active Program. And I think colleagues from the law school might have been involved with some of these discussions as well, coming under heavy criticism, the program, not the colleagues. So I think, you know, there are a lot of broader issues, I think, that are raised by Julia's work that we, you know, can fruitfully continue to debate and perhaps talk about a bit more today as well. So thanks very much, Julia, for those really great insights. And I guess my role is to maybe kick off with a question. I've got a couple saved up, so we'll see how we go. If others have pressing questions, please jump in after this, but otherwise I'll keep going. So I think the theme of colonisation, which you touched on early, I think it was really notable to me this year in their report that the IPCC recognised that colonisation, for the first time, they talked about colonisation as an underlying driver of climate change. And I've seen a bit of discussion about how kind of remarkable that was from an institution like the IPCC. And you also talked about CO2. I wrote it down. What was it? CO2 colonisation, which after I wrote it down, I thought, oh yeah, that makes sense. So how carbon capture could be another instance of colonisation effectively, or example. So I think one key aspect of colonial administration around the world was the enclosure and zoning of lands to reconfigure property rights and access. And in political ecology, we talk about those processes as state territorialisation. And these kinds of state interventions and territorial reconfigurations are ongoing today. And in my work in mainland Southeast Asia on REDD+, I've found that apart from serving these international agendas, REDD+ can also enhance state authority in relation to forests, or even enable new modes of state territorialisation. So I'd really love to hear your thoughts on kind of the state role in this kind of international to local dynamic that you're describing in your book, and especially on how you think REDD+ might enable or constrain state power and authority. Julia.
Thank you so much for all those comments. Yeah, I think there is so much to unpack. I have a whole discussion in the intro of my book too about this long, discussion for the last 10 years. REDD's dead. No, REDD's still alive. That it keeps trudging on this zombie type state. And I had this sort of, crisis of confidence too when the book was about to come out. I was going, oh, this is like, it's over. This is completely irrelevant now. And then sort of with the whole talk about net zero, I'm like, no, unfortunately, this is still hanging on. It's still got legs. It's still got relevance. That it somehow remains unresolved in lots of ways, that key decisions about REDD still haven't been made, but it still keeps somehow going along and transforming in particular ways, which I do find really fascinating. On the question of state territorialisation, I'm sure you've got more insights on this than I do, but I really would echo what you're saying, that you do. I didn't end up looking that much at some of the national dynamics because just simply, the number of countries now engaged in REDD projects in order to do a sort of detailed analysis of them in that place. I sort of went to look much more at that sort of global level, which I think abstracted from some of those dynamics. Some of the developments I was following most closely was with REDD in Indonesia. And there it was really interesting too, sort of seeing how the state, one, was very disaggregated, particularly in that context where you had constant battles between the Ministry of Forestry and the Ministry of Climate Change, or the REDD task force, and the different parts of the government, you know, and the state also fighting out, and that how that also found its way into sort of quite technical parts of regulations, that you sort of saw those conflicts between different parts of the state and their different agendas playing out in, like, maybe how you determine baselines or various other things. But certainly I think too, as part of some of the technologies that are really crucial in the space of REDD, is that sort of remote sensing from satellite imagery and stuff of forestry. And I think that plays a crucial role in the sort of the territorialization that's happening, you know, in the same way that we might think about mapping in previous rounds of territorialization. I think forests have always been a crucial part of sort of territorialization processes. And so we're sort of seeing that here again, but I think in some ways, yeah, the role of the state is crucial. And I think that's recognised by all the REDD readiness initiatives by the international development institutions, that is really about creating the type of state and the type of state regulatory infrastructure that can manage these things. But I think it is a much more managerial approach of the state, rather than maybe that sort of you know, the type of the modernist sort of state that we might associate with, you know, James Scott seeing like a state and that sort of approach to scientific forestry that he talks about there. It is, yeah, I sort of thought about more in this sort of managerial and oversight sort of role. Sorry, I'm getting a bit unclear here, but yeah, and I was really interested in the role of those technologies, in particular satellite imaging, were playing in that process of territorialization as well.
Thanks, Julia. Sango, do you have another question, or shall we go to the audience?
I'm happy to go either way. That was, yeah, well, are there other questions lined up, Tina, or what would you?
There is a couple of questions. So I will ask one question from the audience, and then if we have time, we can come back to you.
Yeah, sure. That sounds great. Thank you.
Yes, the question is from Christy Clark. And basically the question is, to what extent similar dynamics infect all other areas of climate politics and climate law? And her example is adaptation.
Thanks so much for that question. I haven't looked at adaptation in enough detail. The area that I've looked in more detail at is loss and damage, as well as sort of this area of mitigation here, climate change. In the area of loss and damage, I think we see a really similar dynamic. Obviously, the obscuring of questions of historical responsibility. And I think, again, too, this the fact that a lot of work is happening outside the official framework of the UNFCCC in developing particular responses to loss and damage. So in a piece I wrote on that, I traced also the role of the World Bank in setting up sort of various forms of privatized risk management approaches and privatized insurance schemes, micro insurance schemes as responses to addressing loss and damage. We also see sort of the use of financialized mechanisms such as catastrophe bonds operating in this space. And so I think there again, we see this dynamic of historical responsibility being avoided, but instead we have this promotion of responsibilization at the local level, that people need to take responsibility for preventing and mitigating and addressing the risks that we are invariably going to be faced with climate change through these sort of much more insurance-based and financialized processes. So I can't say that much about adaptation, unfortunately, because I haven't really done that work, but I would worry that that similar dynamics are also applicable in that space. That said, I think adaptation, there's certainly been a lot of contestation and a lot of pushback, also with a lot of communities using climate mitigation to really build much more grounded models of resilience as well. So it'd be really interesting to sort of see how that's actually playing out. That I do think that I'd hope that in adaptation there might be a slightly more positive story to tell, but I can't give any conclusions. I'm sorry.
Thank you, Julia. And for those interested, I have added the link of the Griffith Law Review in piece by Julia on loss of damage on the chat. Sango, the floor is yours again, and I have one more question from the audience if we have time at the end, but the floor is yours.
Okay, great. Yeah, so Julia, I was interested in, because I guess I've had limited scope to look at the actual kind of design of the contracts that can underpin REDD scheme, although I've seen attempts to sort of implement these once they've been developed. And I guess in the schemes that I've studied, you know, you've got these REDD agreements in place that specify certain sorts of land use practices will take place, or restrictions on land use, for instance. But then on the ground, you might see things like the continuation of things like illegal logging or kind of substantial forest clearance in these REDD designated forest areas. In other words, kind of business as usual in these spaces that are covered by some kind of a REDD agreement. So I guess my question sort of around that, as someone who's worked more on the kind of design and implementation of these sorts of contracts, is if the schemes themselves are ineffective and are out of kilter with what's in the contract or written agreement, what does that sort of mean about, or what does it tell us about the exercise of power and authority by the international community in relation to these forests? Does it mean that it's kind of a flawed set of agreements, or, you know, are they actually not powerful when it comes to what happens on the ground at these REDD sites?
Thanks so much. I think there's a couple of different things going on there. Like, firstly, at one stage I talk about like just how difficult a lot of these spaces are to govern. Like, they are in lots of cases very remote, very difficult to access, and how that sort of that nature of that terrain itself sort of has meant that a lot of REDD governesses have to operate on this terrain of compromise, you know, and that there's been, you know, much less, you know, it's not this sort of clear idea and implementation on the ground, that it's been much messier. And then also the question, you know, the REDD contracts is so complicated because, unlike with the clean development mechanism under Kyoto, for example, where they have reforestation projects, it was seen as a project-specific project. So it just really matters what happens in this project area. You know, you plant the trees, do they grow? But REDD is sort of envisioned much more at a jurisdictional scale. So it's not just what happens in that project area, but what happens across the whole country. So there's questions then too about what areas get zoned for REDD projects as opposed to what's happening elsewhere. And you have at the national, and this is, I think, where a lot of the national level stuff comes in too. You have, like in the case of Indonesia that I'm most familiar with, you have the simultaneous pursuit of the expansion of palm oil industry and some of those industries that are driving deforestation alongside REDD projects, you know, which for a lot of local communities, they experience both of these things as driving them out of their land. So you have these different processes happening there on the ground. But yeah, then I do think that question of, you know, how does things actually play out is so messy. And then what are the mechanisms for enforcing that against whom? And this is, again, you know, often you have multiple contracts as well. You might have a contract between the NGO and an international actor about the provision of carbon contracts, for example, but then they try and do like much more local level contracting at that village level. And again, it's like, okay, which contract would be enforced under what law? I look at some of the international contracts, they have often international, you know, enforced under the law of New York or London or under international arbitration processes, but I don't know what the, you know, the more village level agreements, what those processes of enforcement are. And so I think that's partly why, you know, REDD's so messy too, and why I sort of think about it as a vision and an idea in lots of ways too, and this process of trying to put things in place that would actualize this idea, but that it's always never quite actually actualized the way it's envisioned either, and can't possibly really be because of all these both just the messiness of the reality of what's happening on the ground, but also the competing incentives haven't been taken away to pursue all the other land use activities, and how that plays out at the local level, how that plays out at the national level, that states are pursuing alternative, pursuing the industries that are driving deforestation at the same time that they're seeking to pursue REDD. And you have these mixed incentives producing this really messy reality of how things actually play out. So again, the case study that I was most familiar with was with the Australian-sponsored Kalimantan Forest Carbon Partnership, which was Australian government through AusAid and Department of Climate Change trying to do reforestation on the ground in Kalimantan. And there was a case of they promised tree planting would happen on this land that had been cleared as part of a ex-Sahara era mega rice project, and there a lot of the trees weren't planted, or the trees that were planted didn't survive, and you have again that messiness. And then in the end, when the government extracts themselves from it, they're like, oh no, it's just a demonstration activity, we're just trying to learn things about methodology and procedure, we shouldn't be evaluated on what we actually did. And then when you ask, well, what did you learn from it, it's not really clear what the learnings are either. And I think that's also why I find this whole rhetoric of learning by doing, that's such a key part of how REDD is operating, so disturbing, because there's never really a clear thing that you can evaluate these projects against, because they're just like, oh no, this is all feeding into future developments and future learnings, and it's all just part of the demonstration process. I think creates a really dangerous, murky terrain, and I think that's part of the governance of these projects as well. So sorry, that was a rather convoluted answer, but I hope it got at some of those questions.
Yeah, thank you. The real REDD never failed. It just wasn't tried. Sango, do you have any concluding questions or thoughts before we bring the seminar to an end?
Oh, no, that's fine. Thank you. I mean, I think some really great thoughts there from Julia. I think definitely the whole issue of what is REDD actually really struck us when we were doing our research, and that's why we came up with the idea of actually existing REDD, which is kind of what seems to play out, rather than some, whatever the model or ideal is that different practitioners and agencies bring to the field.
Yeah.
I thought that was a really productive discussion. Thanks again for involving me.
No, thank you so much.
Yes, and it was, I was going to say it was really interesting to me. I hope it was also to our attendees, seeing two people coming to the same question, perhaps carrying very similar sensibilities and values, but approaching it methodologically and disciplinarily from such different angles. I think that was fascinating to me. Thank you very much to Sango for her time and her generosity, and thanks to Julia for her time as well, and of course for all the labor and energy that went into writing this terrific book. And thanks to everyone for attending the seminar.